General. My name is Edwin Agenda. Currently, my learned colleague Felix Olindi and Melissa Nyanja. We are carrying on behalf of the applicant, the promoters and solar wheels, the matter of the promoters and solar wheels against Green Drive and Illegitimate. My lords, this court has appointed us 30 minutes and we shall use this 14 minutes to address the matter of jurisdiction and admissibility and issue 1, and my colleague Felix Olindi will use 16 minutes to address this court on issue 2, 3, and the prayers for the applicant. My lords, a dominant undertaking such as Green Drive has a special responsibility not to allow its behavior to.
So you said you're using 14
minutes.
And then your colleague is using
16 minutes.
Alright.
Much obliged. My lords, as I was saying, a dominant undertaking such as Green Drive has a special responsibility not to allow its behavior to injure the competition within an internal market such as that in the state of Uganda. My lords, the applicant will submit to you, and by the end of the applicant's case, you will be convinced that indeed Green Drive abused its dominant position and injured the competition within the state of Uganda. My lords, the applicant first of all contends that this court has jurisdiction to hear this matter. Secondly, my lords, the applicant, in regards to issue 1, will submit with 2 main heads of argument. The first being that the exclusive agreement entered into by Green Drive and Sky Connect included and amounted to a refusal to deal, and the second being that the applicant was foreclosed from access to supply of sources, contrary to section 10, subsection 1, paragraph B of the East African Competition Act. Made this report, I will now submit on the matter of jurisdiction.
The second argument
is that the applicant was foreclosed from access to supply sources, contrary to section 10, subsection 1, clause B, the East African Competition Act. May it please the report, I will now continue to submit on the matter of jurisdiction. My lords, this being the High Court, this court has unlimited jurisdiction to hear any civil matter brought before it, and this is provided for under Article 137 of the Constitution of the Republic of Uganda. Furthermore, this court has pecuniary jurisdiction to hear this matter because the pecuniary amount subject to this dispute amounts to 100 million Ugandan shillings, of which 50 million shillings were imposed as a penalty on both Eco-Motors and Solar Wheels who are here before the Honorable Court as a joint venture. Therefore, we submit that this court has the jurisdiction to hear this matter. My lords, I will now proceed to argue on the first argument under issue 1. The first argument, as earlier advised to you, my lords, is that the exclusive agreement created a refusal to deal. The refusal to deal is the one that is provided for under section 9, subsection 2, clause A of the East African Competition Act, and the refusal to deal is one of the acts that amounts to abuse of competition. It is a concerted practice. Therefore, much obliged, my lords. My lords, the East African Competition Act, my lords, the state of Wakanda is a sovereign state within the East African community. It is on that premise that this state is taken to have acceded to the East African Competition Act. And even though the East African Competition, even if the state of Wakanda has not ratified the East African Competition Act, my lords, I would like to guide you to refer to the decision of Atamba Hussein versus Uganda National Roads Authority, civil suit number 18 of 2021, where the court in that matter considered the several UNESCO conventions in regards to cultural heritage rights without considering whether those conventions had been domesticated by the state of Wakanda.
Before you proceed, I understand the East African Community Competition Act has a certain scope of applicability which requires a cross-border aspect. What cross-border aspects can you cite for us in this particular scenario? Is there any cross-border effect here among the claims you make?
Much obliged, my lords. My lords, when a company is in a dominant position, it is able to have to trade not only within its internal market, but also has the capacity to trade outside its internal market. Outside its internal market. Therefore, my lords, with the applicant.
Your facts point to cross-border practice, because it's not in the facts. Is it in the facts?
My lords, that is not exactly provided for in the facts, but.
So how does the act apply? It is not cross-border effect. It's a question of scale.
My lords, if I am understanding your question well, you want me to discuss the applicability of the East African Commission Act in regards to cross-border.
Yes, and your facts before you.
Yes, my lords. The facts before us in this case. In the facts before us in this case, it is important to note that Brunei is a dominant power.
Within Wakanda, yes.
Within the state of Wakanda, yes. Brunei being a dominant power within the state of Wakanda means it has that capacity to have cross-border trade outside.
So there's no effect yet, but it has the capacity to.
No, my lords, not too much. The effect of that dominant position is within the state of Wakanda. Because if within the state of Wakanda, Green Drive is able to, if within the state of Wakanda, Green Drive has that power to trade, that dominant power, then it can easily trade within, it can easily trade outside its.
Are you speculating?
Perhaps the easiest way around this is for us to hear from you about whether you must demonstrate an actual cross-border effect or a potential cross-border effect, and with authority.
My lords, the premise that I will now submit to that question is that from the facts, specifically paragraph 2, we are guided to refer to decisions and judgments from other common law jurisdictions, such as that in the East African community. So that in effect makes the East African Competition Act applicable to this matter.
Decision and judgment. Is the East African Competition Act a decision, or is it a judgment?
My lords, if I have understood the question, you want me to distinguish between the case law and statute law. But then, my lord, I would like to be guided. I would want me to answer that specific question.
You must convince us. That's great.
Much obliged, my lord.
No, you cited paragraph 2 and you said that it allows you to refer to decisions and judgments from other common law jurisdictions, such as those in the East African community, yes?
Yes, my lord.
And the question was, in application of the East African Community Competition Act, you have to show potentially a cross-border effect. So the judge asked you, do you have to show an actual or potential cross-border effect when you cited this paragraph?
Which doesn't answer my question.
Exactly.
Yes. Much obliged, my lords. So what the applicant
basically, I'm asking if you've read anything, if you've encountered any authority that speaks to what kind of cross-border effect needs to be proven for this act to be applicable.
Much obliged, my lords. I will leave that question to be answered by my colleague in the next submission. Okay. I now like to submit on the first issue, on the first argument under issue 1, that continue to submit on that issue about the exclusive argument leading to refusal to deal. My lords, as I had underguided this court, that refusal to deal is one of the anti-competitive practices. And so, in the state of Wakanda, we have the competition bill. For persuasion purposes, this bill is not yet into place, but in order to persuade this court, I would like to move this court to...
By into place, you mean has not yet come in force?
Much obliged. This act was passed by the parliament, but
I'm just asking about the language you adopted. By not into place, what do you mean? It's not into which place?
Much obliged, my lords. The competition bill has not yet been assented to within the state of Wakanda.
And
by the head of state
not.
of the state of Wakanda.
And therefore is not?
And therefore it is not law. and can only be persuasive before this honorable court.
Yeah, but please try to desist from using words like not into place, into which place.
Much obliged. My lords, paragraph 9 of this fact is what exactly points out the applicant's argument on the refusal to deal. When the applicant, Ecomotors and Solar Wheels, tries to obtain a license from SkyConnect in order to access AG signals, the applicant, SkyConnect, refuses to grant the applicant that license, citing that exclusive agreement with Green Drive. Therefore, it only points to one aspect, that Green Drive and this exclusive agreement are Green Drive and SkyConnect within this exclusive agreement do not allow other competitors within the state of Uganda to compete in that aspect of accessing 8G signals in order for them to boost their electric cars in regards to the remote charging, because that is the main aspect and that is the main reason as to why the 8G signals are being used. My lords, on the issue of a refusal to deal, I would like to cite this honorable court a case of De Montis, Catering Roma versus Aeroporti di Roma. The decision of it is an Italian case, a decision of the Italian court, in which the principle of refusal to deal was discussed. And in that case, where a state-owned company controlling the Rome airport had that monopoly over that airport and the supply of services, when the applicant approached the airport, the applicant approached that state-owned entity, the respondent in that matter, to access services and provide services to the airport, the applicant was not allowed to, the respondent did not allow that applicant. Therefore, in that decision of that case, the Italian court, the Italian Antitrust Authority found that this respondent, the respondent, Aeroporti di Roma, had no justification for not allowing the applicant to access that airport and supply services, because that act of not allowing amounted to an extension of the respondent's monopoly power within the airport. And therefore, that case cites how that refusal to deal in fact raises the monopoly power of...
I see your time is fast running out. I'm interested in knowing how courts have dealt with the issue of refusal to deal from what tests are there to determine whether there is a refusal to deal or whether a refusal to deal would be justified within antitrust law. And more specifically, I'm interested in knowing how, in this case, this refusal to deal affects your client negatively in any way.
Much obliged, my lords. The tests applied in looking at that refusal to deal amounting to an anti-competitive practice. One of the tests will be that the courts will look at the nature of the competition within the market, and the courts will also look at the position of the competitor within the market, and the courts will also look at the position of the dominant force, dominant undertaking within that market. So when the courts look at those three factors, they will be able to decide on whether this dominant undertaking in fact abused its dominant position by entering into an agreement with the refusal to deal, because it actually used that dominant position as an advantage.
Where do you find these factors? What is the source?
Yeah, what's your authority for that?
So the factors you're citing, where do you find them?
My
is
lords,
it in the deal, or are you citing the deal now?
My lords, those factors were discussed in the previous case of I cited in the case of the Moot Catering Roma versus reporting Roma.
Is it binding this court?
The decision is a persuasive one for this scenario. My lords,
Your time is up.
much obliged.
So that's it. That's how you conclude. Is that all?
Just bow down.
You have no ask.
Much obliged, my lords.
You had a whole head of argument. I'm interested in actually hearing this foreclosure. But we can't give you what you know.
So we are just saying that is it.
Thank you for your time.
My lords, I beg to apologize in regards to that.
You beg to apologize.
Oh, you apologize.
My lords, I apologize in regards to that. As earlier you communicated that time was not a factor for this my report, and it's came to me when my
The time you're spending making that explanation would have been better used moving this court, or so even if we were to accommodate you for any amount of time, we probably have to take that time out. Okay. So do you have something to say?
Yes, my lords. So there are four in regards to issue one.
Your time is up. You have anything.
Yes, I'd like to present what
But your time is up. You have to. There's something you have to do before you present.
Then you continue.
My lords, I request for 2 minutes.
That's too much.
Summarize.
You've already spent half an hour. I'll give you 1 minute.
Much obliged, my lords. In regards to issue 2, on the issue on the fact of foreclosure, in regards to issue 1, the second argument
Your
of
second
foreclosure, yes, it is evident from paragraph 9 again of the facts for this case that the applicant was foreclosed from accessing that supply, that ATG, which is supplied to its remote charging, to its smart charging chip, and therefore that foreclosure is one that amounted to an abuse of green rights.
Under section 10, what does a foreclosure to from access to supply of resources amount to? Like what specific antitrust violation is there? Because it's merely a component of a certain antitrust violation. Which antitrust violation is that?
Much of that, my lords. Under section 10, under section 10, what amounts to
section 10 of what?
Under section 10 of the East African Competition Act, my lords.
That earlier you
told us you don't understand the basis within which you are playing this.
So why should we?
Much of that, my lords. I did not.
You're actually saying you leave the question to your colleague to
address it.
You also want to leave the section 10 to your colleague.
I know I will address on this section 10, and my colleague will address on that question that has earlier been asked.
Alright.
Much of that, my lords. In regards to section 10, that practice of a dominant possession includes whereby customers or competitors are foreclosed from access to sources of supply from access to outlets. And this happens where...
What does that amount to? And in the grand scheme of things, there is a specific antitrust violation that is being addressed by section 10. What antitrust violation is that? What does it amount to when a distributor or a supplier forecloses a source of supply? What does that amount to?
My lords, much obliged. That would amount to production of low quality goods by that entity.
I'm asking about the specific violation, antitrust violation that section is in place to curb. And I'm asking what is that a component of? What is foreclosure from sources of supply a component of? What antitrust violation is that a component of?
Much obliged, my lords. I will answer that question by drawing to what exactly the backbone of competition law is. The backbone of competition law is to protect the consumers from exploitation of any form. Therefore, section 10 addresses that
violation. I thought it is
violation.
section 8 that addresses exploitation of consumers under abuse of dominant position. It is section 8 that, as far as I can tell, that addresses exploitation of customers. Section 9 addresses a different thing. Section 10 addresses a different thing. I'm interested in knowing what does section 10 actually address.
Yes, under section 10, this section specifically addresses vertical distribution agreements within made by a firm in a dominant position. And this agreement, this vertical distribution agreement that will be made by a firm in a dominant position, this agreement should not engage in practice whereby its customers or competitors are foreclosed for access to supply resources.
So it took you long enough that you got in there within 2 years to proceed.
Much of that, my lords. I will now yield floor to my colleague Felix Olindi to address this code. Thank you.
May it please this honorable court. My name is Felix Olindi, counsel for the applicant. I shall use 60 minutes to submit on the second and third issue, and also submit our prayers to this court. The case for the applicants.
Maybe you can start with the date we have with him. Are you also citing the EAC Competition Act? If so, on what grounds, and also addresses on application?
I'm going to submit on it.
Your lordships have asked that you start with that.
Your lordships, it's the applicant's submission that competition law does not firstly happen in a vacuum, but two, it does not happen in one jurisdiction. That the impacts of that over time, companies are always having a cross-border element. That's why Google, Microsoft have had antitrust cases in different countries. Your lordships, it's our submission that
that's very presumptuous. if Google, right, which originates all the way from Europe, comes here, it doesn't mean necessarily that we're bound by their laws.
Your lordships, the submission of the applicant is not that we are necessarily bound. But if there is just one thing that competition law is going to argue on, is that we do not want anti-competitive cartels because they have a negative impact on competition and on the consumer enjoyment of services. Your lordships.
Brilliant. What's the basis of that?
Your lordships, firstly, I would like to persuade this court with the 1998 recommendation of the Organization of Economic Cooperation and Development of the European Union, which is the basis for some of the most important decisions on antitrust laws and competition. Your lordships, this legislation.
So let's bring it home.
Yes.
Uganda has had, because we're asking a very basic question, so that you merge into the EAC.
Border effect.
Exactly. So I'll give you an example. The competition bill of Uganda started way back about 1998, right?
Yeah.
But there are traces of what we're asking. So could you move that argument that you just said about the European Union? If you know the history to the East Africa, if you know the history of the competition bill that Uganda now seeks to make law.
Your lordships, firstly, it's the applicant's submission that being party to the East African community, Uganda, the Republic of Wakanda is required by good faith to follow the competition bill. This is evident in the enactment of the competition bill. That even when it is not necessarily does not necessarily acknowledge the East African competition bill, it has taken steps to replicate some of the key principles in the East African Community Act. With that, it's our submission that this court should therefore be persuaded to believe that even without a possible East African competition.
Back to the facts you asked before. What is the effect with the practice of the respondents?
My lordship, firstly, by the nature of this industry, this is not an industry that is close to one jurisdiction. Consequently, the producer of an electric car would want to sell it to another jurisdiction.
That hasn't happened yet in your facts. It's a case to answer. It hasn't happened yet.
My lordship, it has not happened.
So why are you using the act?
Your lordship,
When there's no cross-border effect yet.
The reason the applicants use the act is because the principles that it establishes on competition competition and antitrust law are the same principles that are enunciated in the Competition Bill of the Republic of Uganda. Your Lordships. May it please this court, I shall proceed to my substance. My lords, my lady, the case for the applicant.
I think let's stick to your Lordships, please. We don't
not
have
your
any
lady.
ladies here.
She's not your lady, so
We want to protect
Your
the member of the bench.
Your Lordships, the case for the applicants is very straightforward.
Is it straightforward?
Yes, my lordships, as I will demonstrate.
We are
Two
not-
companies,
We are your Lordships, but you can't say my Lordships, please.
much obliged.
Yeah.
Two companies, each with a dominant position and with access to an innovation that is essential for market growth, relevance, and development, enter an agreement to foreclose access to this technology from other competitors. The effect of this is that these other companies, Eco Motors and Solar Woods, cannot remain as competitive as Green Drive and Sky Connect are in the market. Out of despair, your lordships, these companies decide to create something similar so that they can access the same technology. Your lordships, with a foreclosure of access and limiting of competition, the question therefore to this court is whether which of these two companies, by virtue of their action, amounted to an anti-competitive cartel, and even in innovating in such circumstances, is it really justifiable for us to say that the innovations and collaboration in research and development by Solar Woods and Eco Motors is illegitimate? Your lordships, that's a question you will answer by the end of my submission. Under the first issue, under the second issue, firstly, we submit that unlike the actions of Green Drive, the actions of Solar Woods and Eco Motors did not have any appreciable effect on competition. I would like to draw, and then secondly, we shall also submit that the actions of the joint venture, unlike the actions of Green Drive and Sky Connect, do not fail. Unlike the actions of Green Drive and Sky Connect, do not fail the test as presented in the as effective actor principle, as we shall elaborate in my submission. For the third issue, we shall submit firstly that the innovation developed by the applicants passes the test as laid out in the Industrial Protection Act for novelty, inventive step, and industrial applicability. And then lastly, even though this court is not moved by this, it's our submission that their usage amounted to fair use as enunciated in Google versus Oracle. And then thirdly, we shall submit that their use, even when may not have been innovative, like that is a question you decide, amount was in the public interest, and that's the goal of competition law and antitrust law.
I am interested in knowing what amounts to an anti-competitive cartel according to various laws.
Your lordships, an anti-competitive cartel is any collaboration between two companies that has an effect on competition.
And
Your lordships,
in this case, you have paragraph 7 defines your companies as other prominent electrical vehicle manufacturers, right? You formed a collaborative partnership through a JV to develop electronic vehicles and with the aim of starting cost-effective business. And then particularly, I'm particularly interested in the part where you share pricing strategies. You exchange information beyond the scope of the collaborative partnership, including, this is paragraph 13, sensitive business details, pricing strategy.
You cannot remain a dominant factor.
You sound like an expert.
Is an assumption? Are there statistics that show?
Your Lordships, it's not an assumption, but there is case law to prove that.
Which case?
Your Lordships, in the case of Google versus, Oracle, Your Lordships, in the case of the United States versus Google,
The US sued. Is the US the party?
yes, my lord. So in the case of the US versus, I apologize. In the case of the United States versus Microsoft Corporation, reported at 253 Federal Reporter, third series, page 34, at the District Court of Columbia in 2001. This court, the facts were firstly that Microsoft, being a dominant manufacturer.
Let's go by the principle. Yeah, tell us the principle.
Your Lordships, the fact that you have the latest technology puts you at a higher advantage than those that do not have that technology. And to that extent, you become the dominant power and they lose the dominance they have in the market.
But you see, from the facts, even you have the same power, you have the same technology with you. So how come there is dominance? Yet you have the same power they have.
Your Lordship, unless I don't understand what you're trying to tell me.
No, I mean the point is that in the facts, even your applicant has the same technology the respondents have, so you both have the same.
Your Lordship, at paragraph 7, we have not gotten the AG technology. The making of the AG technology comes, of the FCC enabled chip with access to the AG technology, comes after the refusal to grant us the FCC enabled technology. That's why we created it. So by virtue of paragraph 7, we are not at a dominant position as yet, Your Lordship.
What has stopped you from getting it?
Your Lordships, firstly, it's our submission that by virtue of the fact that Green Drive creates this technology that is already declared, that becomes essential in the market, other industry
Green Drive that creates AG.
Yes, it creates the SCC technology with access to the AG technology. By virtue of that, as long as it creates and it has been determined as an essential element or a standard essential patent, industry actors lose the ability to create similar products that navigate around certain barriers. Those barriers have been created. For example,
That's what you're saying. What shows that you are being banned as other industry players from creating something similar, something around it? What has stopped you? Demonstrate from these facts and notes.
Your Lordship, to answer your question, from the unreported case.
I'm interested in the facts. Before you take me to any case, from these facts, how have you been banned from creating something similar?
Your Lordship, we have not been banned, but the case of Huawei versus Digital has the same scenario. And on principle, the court in that case say that as long as something has been declared as essential in the market, other industry actors or implementers forego the ability to go around to create an element that is even better than that. So sort of they become locked in that system of that AG smart chip. Then it becomes the responsibility of that particular actor to license it to other actors under fair, reasonable, and non-discriminatory terms. Because we have the industry has agreed, we need the AG technology. Green Drive has created it. There is no need for us to create the same technology. And because Green Drive realizes that there is no need, it must make it accessible to other implementers like SolarWheels and EcoDrive under fair, reasonable, and non-discriminatory terms.
So there you're asking us to apply what rule, what principle for us to determine that this was an anti-competitive behavior.
Your Lordships, first of all, the fact that they bar competitors from accessing the market or products relevant to the market, Your Lordships. Yeah, under section 6.
I'm asking about the rule or principle or test. I asked your colleague for the test.
Yes.
I didn't get a satisfactory answer. I am interested in what test do you want this court to apply to determine whether there was anti-competitive behavior. There are several tests for determining
Anti-competitive.
So what test do you want this
in this
to
case
apply?
of the refusal, Your Lordships.
In both cases, you have spoken about what you call anti-competitive behavior. So I'm asking, what test do you want us to apply to determine whether that is anti-competitive or not? Because these different tests could result in different results.
Yes, Your Lordships. Your Lordships, firstly, we would like this court to apply the appreciable effect on competition test as laid out in the 1998 recommendation of the Organization of Economic Cooperation and Development. These recommendations that are followed by the European Commission and courts laid out.
From your submission, you seem to be leading us to the rule of reason by saying that it is unreasonable to expect other competitors to develop their own technology in the circumstances. That is why I'm asking you, are you trying to have this court apply the rule of reason? And what is the position of jurisprudence on the rule of reason?
Your Lordships, we would like this court to consider that the doctrine was standard essential pattern.
Standard
essential pattern. Your Lordships, a standard essential pattern, as defined in the case of Huawei versus Bukoto, is a patent that is necessary for the growth that has been recognized as very important for the growth of that. Limit competition, but also reduce their ability to become effective actors.
So, good thing you speak about effectiveness.
Yes.
Address this court on the as efficient competitor test.
Your Lordships, the as efficient competitor test is very simple. That when one, Your Lordships,
the time is up.
Saying that my time is fast spent, I request. I can't request the court.
Where's your voice going low?
Seeing that my time is fast spent, I humbly request this court to grant me additional time.
My court to answer prayer.
I pray.
Want to make a prayer.
I pray that this court
How much time?
1 minute to address you on as effective actor.
Very quickly.
Yes. My Lordships, the as effective actor principle.
As efficient
competitor principle, Your Lordship, simply means simply questions whether the actions of one actor, especially by foreclosing access to a particular product, limited the ability of other efficient actors to act in the market.
So, in your specific issue, what is the effect of this test?
Your Lordships, because Green Drive foreclosed access to the AG technology from...
You know your issue is about whether you are a cartel.
Yes.
Okay, so now tell me, did you, by doing what you did, affect other efficient competitors from, affect their ability to provide an efficient?
Your Lordships, it's our submission that our actions did not in any way affect Green Drive's ability to become an efficient competitor, because firstly, our innovation wasn't entirely that of Green Drive, but of Green Drive. But secondly, there is nowhere in the facts where we deny access to this AG technology that has the ability to access 6G, 7G, and 8G to Green Drive. On their side, when we need to use this technology, they refuse to give us, and they become...
Then the argument then be made that the reason why you do not get protection is because by the time they were able to innovate the SCC, get to leverage the 8G UHF, before you came up with it, you're not as efficient a competitor as they are, and therefore shouldn't be protected.
Your Lordships, if they weren't as efficient a competitor, then
who is they?
if we were not as effective as a competitor, then we would not. Principally, they would not have refused to give us this technology because they would not be threatened by the competition we would bring to them, Your Lordship. But because we have an efficient competitor, they refuse to give us for fair competition. Your Lordships, in conclusion, I'd like to submit my prayers to this court. Firstly, that the conduct of Green Drive and Sky Connect
doesn't sound like a prayer. Make a prayer.
Your Lordships, it's the applicant's prayer that this court finds that the conduct of Sky Connect and Green Drive amounted to abuse of a dominant position. Secondly, that the joint venture, the applicants, did not transform into an anti-competitive cartel, and therefore the fine of 50 million Wakanda shillings each is not justified, and therefore this court should set it aside. And then thirdly, that the innovations between the joint venture were actually legitimate.
Should the agreement between the two stand, or we nullify it as well? You want it to remain standing?
The agreement between
Drive and
Sky Connect.
This agreement should not stand because, as I've demonstrated to you, it has the effect of stifling.
So what is your prayer in respect to
It's
in respect to the
actual agreement?
We also the applicant prays that
how many applicants we have? The applicants.
It's one applicant actually.
Yes.
The JV.
The JV.
much of life. The JV, it's the JV's prayer that this court nullified the joint the collaboration.
I want to let you go, but in 1 minute I need you to specify how your collaborative research, which includes aspects of pricing, pricing strategies, actually could possibly be among the exceptions to anti-competitive behavior. Don't you think that is one of the very kinds of agreements, kinds of collaborations that would be envisaged for prohibition under, I think it's section 8 of the ESC Competition Act. Because I feel like everyone is skirting around it, but you can't just tell me innovations are okay, but is this research actually among the exempt research? Answer that and please let the respondents address you.
Your Lordship, section 6 goes to A, B, and C are our defense.
Yes.
Firstly, the exception
Of what?
Our defense to any
No.
allegation.
Section 6 of what?
Section 6 goes to A, B, C of the East African Community Competition Act. Firstly, they give an exception that even when there may be potential antitrust concerns, an innovation, a collaboration that is concentrating joint research and development, specialization of production or distribution. We are producing electric cars with access to it.
What does the price show for?
And then lastly, standardization.
Because the pricing
Where does the
strategies,
pricing
my
standardization.
like you sharing pricing strategies need to be that thing that throws you under the bus.
And where in paragraph 2 does pricing fall?
Your Lordships, paragraph 12 of the facts says that paragraph 13 of the facts is what you're referring to. But in their defense, our defense as the joint venture, everything we do is in line with our technological innovation strategy. At paragraph 7, we tell you our strategy: create cost-effective ride-hailing service with access to this technology. Competition law is not about strictly promoting competition or protecting the companies or competitors, but it is focused on protecting the consumer. From our objectives and our strategic plan, our plan or our collaboration is rather consumer-centric, unlike the plan of the relationships.
Okay, thank you very much. I have more questions, but we're out of time. And I'll ask the respondent.
Your Lordships, once again, I'm for the respondent. I will be using 14 minutes to submit on the preliminary issues of jurisdiction and admissibility, and subsequently issue 1, and subsequently co-counsel will use 16 minutes to submit on issues 2 and 3. Your Lordships, this matter arises from a decision of work, which is a parliamentary committee in the ministry. That is, and that decision has been reached after thorough investigation. On the premises, my lords, the applicants have submitted before this honorable court that as such this court is vested with unlimited original jurisdiction pursuant to Article 139 of the Constitution of the Republic of Uganda. Lordships, it is prudent, even in argument, that this court notes that competition law in and in itself is not a legal regime that has been traversed to a great extent by the Ugandan courts and legal system. To that end, even in my submission and co-counsel submission, we shall rely heavily on persuasive jurisprudence and shall cite a lot of persuasive statutes and articles to the end of persuading this court to come up with a decision on competition. That in perspective, my lord, and the fact that this decision comes from this hearing comes from a decision of work, it is prudent that we find it that the jurisdiction of this court must be appointed. Notice here, my lords, that we do not necessarily object or contend the jurisdiction of this court. However, we simply support that jurisdiction is strong, and that the concept of jurisdiction is very important, that it should not appear not to be strict, and as such we simply wanted to put it pointed. My lords, we will then rely on the jurisprudence.
What do you mean by that last statement?
Put it pointing.
We simply submit that the concept of jurisdiction has been pointed out by a lot.
So you agree with them that the court has jurisdiction, yes. You just want to emphasize it?
Yeah.
Okay, we appreciate you.
Much of that. And we wish to rely on the jurisprudence of His Lordship Stephen of the High Court, highlighting that when there is no proper fraud in that is in Simba properties.
Stephen went and sat in the High Court and just said that statement.
Your Lordships, I'm citing the case in Simba Properties Limited versus Uganda Revenue Authority, case 2011, highlighted that when there is no proper fraud, then the competent court is the High Court pursuant to Article 139. I simply highlight this, my lord, because when you read the Competition Bill of 2022 under Section 27, it seems to suggest that there should be a tribunal established at the level of the High Court to hear this matter. Much obliged, my lord, and I'll just close. It seems to suggest that there should be a tribunal with equal powers to the High Court to hear these matters. But we are in agreement that this tribunal is not yet in place, and as such, we simply wanted to put it straight that this court is exercising such jurisdiction as discussed by the Lordships. I will now proceed to discuss maintainability, which in and itself connotes that before a matter is brought to a court for hearing, you should have exhausted local remedies, and I will not belittle you to those submissions. I have demonstrated that this comes from a decision of a parliamentary committee, and as such, this case is maintained before this court. I will now move straight to submit on the merits of issue 1. The Lordships, issue 1 is whether Green Drive's exclusive agreement with Sky Connect for the access of 8G ultra-high frequency constitutes the abuse of a dominant position. We will answer this issue in the negative under 2 links of argument. First, that Green Drive does not hold a dominant position in the relevant market. And second, that Green Drive's this exclusive agreement is only meant to foster competition. Your Lordship, a dominant position is defined in section 2.
The second head is
that the exclusive agreement is simply to foster competition.
okay.
My lords, clause 2 of the Competition Bill of 2022 defines what is a dominant position, and it highlights 2 important things. That for an entity to hold a dominant position, it must behave independently of of its customers, consumers, and competitors, but also it must particularly foreclose its competitors from entering the relevant market.
Does the agreement do all those things?
Your Lordships, in my submission, I will highlight that it does not, if accorded the latitude. Much obliged.
No, I think the guidance that I'm giving, if such a question is asked, you either say it doesn't and you find substance.
Much obliged.
But where you say later, and then later.
We keep a date.
Keep us in suspense. You may end up getting into your neighbor to present it.
Because same as being
Much
for the action that they said would.
So does the agreement create all those two?
It does not.
Correct.
Because
My Lord, the agreement does not violate simply because we have to first determine what the relevant market in this case is. Your Lordships, I will now invite this honorable court to be persuaded by the jurisprudence of the European Court of Justice, led by Justice Stuart Mackenzie, the decision of United Brands versus the Commission of 1976, where they highlighted that while you're determining what the relevant market is, you must view it from the standpoint of the product. And in this case, Your Lordships, we submit that the product that we must look at is the smart charging chip, not the electric motor vehicle. And Your Lordships, the product we must look at is electric motor vehicles, and the smart charging chip is simply an accessory to those electric motor vehicles. And Your Lordships, when we come to that conclusion, then we will find that Green Rail is a competitor as the joint venture. Your Lordships, as I highlighted, that under the definition, under section, clause 2, of the bill, to behave to an appreciable extent independently of your customers can be highlighted. Customers and competitors can be highlighted.
I'm interested in knowing one thing, right? You have cited that one, you must behave independently of your competitors, customers, or consumers.
Yes.
What does it mean to behave independently of those?
Your Lordships, it means that then that entity can come up with, in the competition market, in relating with consumers and customers, it can dictate on how its products are.
So let us talk. I'm not very convinced by the market, the relevant market yet. We'll demonstrate further, but taking you at where you have taken us, let us examine this agreement. Rather, let us examine your clients, both your clients, because I believe you represent Sky Connect, although you omitted it among your clients when you were introducing. Now, tell me whether you do not behave independently in the making of those chips of any consumer, any competitor, or any customer. Who do you depend on?
We behave independently to that extent.
Yes.
However, my simple submission, and I'm still demonstrating the relevant market, that the smart charging chips are only an accessory to electric motor vehicles, which is the business that even the
So what's the relevant market? Because that's where the contradiction seems to come from.
Yes.
As far as I'm concerned. You first tell us that the relevant market is not electronic vehicles,
My Lord,
but then you tell us that
the relevant market is
which
the
one?
electric vehicles.
Oh, so you spoke about that point?
Charging chip.
Oh, okay. So proceed.
Now, that being the case, my lords, we submit that when the relevant market is the smart charging chip, then Green Rail cannot seem to be the case to have a dominant position as argued by.
Who else has this smart charging chip? Who else has the smart charging chip apart from
Your Lordships, pursuant to Section 7, in fact, the joint venture.
Section 7?
No, paragraph 7
Yeah,
of the facts. The joint venture, that is Eco Motors and Solar Wheels, have smart charging chips, only that they use 6G and 7G frequencies. Yes.
And you, as Green Rail, went to the committee and said that they shouldn't have made these chips because they violate, they did not get the necessary licenses from you and Sky Connect. So how does that not suggest that you are foreclosing competitors from the market, as has been argued by
the Lordships? We went to the committee to suggest that they should not access 8G frequency, which is subject to this exclusive agreement that we are debating today, but not that they should not access entire smart charging chips that can access other 7G and 6G frequencies.
So that wasn't, that being bad, and the intent being inferred from that.
Yeah, clearly, isn't that saying, or you can remain in the, lesser technology while we continue to dominate the greater technology?
Your Lordships, I will invite this Honorable Court to be persuaded to that extent by the jurisprudence in T-Mobile Netherlands versus Rwanda and Basta, the decision of the Grand Chamber of the East African Court of the European Court of Justice of 2009, where they highlighted that to establish foreclosing, that foreclosing must be substantial so that it stops competitors from competing in the relevant market.
Okay, now let's break that down. You start by saying, look, I am going to, I have a chip that accesses 8G frequencies. I go to the only supplier because I think paragraph 5 tells us exclusively offers 8G. You go to that one person, right, that supplies 8G, and you say, you're going to deal only with me to the exclusion of everyone else. How is that not, and knowing very well that if we're going to provide these services of this remote charging, if we're ever going to be able to do it, we need to use 8G. Isn't that you saying I should be the only competitor in this market who gets to access 8G, who only, and by extension, the only competitor who gets to do remote charging?
No, but
how are they going to do remote charging? By using 6G and 7G, which is relevantly slower, right? Significantly slower, right?
Your Lordships, by yes using 7G, 6G, but also go ahead to use things like 9G. That's why I'm arguing, and the argument that I will qualify that this is simply to foster competition, and I will get that argument. And that is why it is so important, my lords, that this court determines what is the relevant market. And I have submitted.
Are you also the same person that's submitting on issue 2?
No, my lord.
Okay,
I have noticed that my time is fast spent. That is why, my lord, that I submitted wholesomely that when you look at United Branch, when the East African Court of Justice, the European Court of Justice, was interpreting what is the relevant market in fresh fruit, and it said that you cannot isolate bananas from fresh fruit, and as such, they could not hold the banana clause as a relevant market and must have looked at fresh fruit. I invite this Honorable Court to be persuaded by the same jurisprudence and consider electric motor vehicles as the relevant market. To that end, you will see that the justification of the exclusive agreement is simply to protect 8G, but also to foster innovation by the joint venture and other competitors to undertake other levels of innovation to come up with a solution. Notice here that from paragraph 1, this country is faced by a challenge of environmental pollution, and to solve that we need various innovations, various ways to get
So you're fostering people in a corner.
By telling them don't use this technology which could help you charge faster, do things easier, I will use it alone, but you, my competitors, don't use this. You're fostering innovation by doing that.
How can you say that your strategy is not a give or take?
Your Lordships, our strategies are give or take. And as you can highlight also from the facts.
You admit that there are people you're saying
It's okay, please, don't
here.
Your Lordships, it is clear from the facts that there is an exclusive agreement that bars competitors that way.
And particularly, I think the thing that you need to address us on specifically is the fact that you have an exclusive agreement with the exclusive provider of a particular technology. How is that not foreclosing a social supply? How do you, or is the response to that the fact that this is a small component, you shouldn't care too much about it, you can operate without it? Is that the answer you're giving to this?
Because then how long will it take to come up with these other innovations that you suggested?
Which already, as they submitted,
yes.
They already submitted that since they're already in the market, it shouldn't be necessary for a person to manufacture these components, especially in a country with environmental pollution as concern.
Your Lordships, considering that my time is fast spent, I will invite this Honorable Court to consider the rule of reason and analysis that was set out in Hostel versus Grant. That your Lordships, first of all, coming up with an innovation like accessing 8G frequencies through a smart charging chip is something that is so substantial and a necessary step that has been taken by an entity. As such, the entity must at first leverage profits from that and then proceed on to sharing. That is why, as you can see, my Lord, as I conclude, that in and in itself, the exclusive agreement is not perpetual. It will come to an end. And to that end, my Lord, we submit that it is not as to be unconditional. competitive, it is simply foster competition as a
How long is the agreement? Duration?
leverage.
How long is the agreement?
Your Lordships, the agreement is not pointed out in the
So
respective
it's perpetual or it's not?
It is not perpetual, my lords.
Because it's not any what, so perpetual.
My lords, it seems to suggest that this agreement can come to an end at any time as a tactical.
Where do you go that?
We could nullify it as what? So should we nullify it?
Where do you?
My lords,
No, you said the agreement in and itself is suggestive that it could be, concluded any time. Where do you find that?
in the light that it does not
The paragraph is that in effect.
So when it doesn't disclose it,
So we can't infer either way, I think that the better answer is we can't infer either way.
much obliged, yes, we can't
Should you assume the time has now passed, so you can now nullify it?
No, my lords. The time has not passed because this agreement is fresh.
It's fresh.
To that end, my lord, I invite this honorable court to be persuaded on 2 grounds. One, that according to the relevant market, this the smart charging chip is not the relevant market, and as such, the Greenbright does not hold a dominant position. It is a competitor as equal as the joint venture. But also that should this court form the opinion that Greenbright is actually a dominant position, then when you look at the rule of reason and analysis, the agreement seems to foster competition through encouraging entities like the joint venture to compete.
I am
You're applying the rule of reason.
Yeah, I'm also again, because I wanted to ask you, you're asking them, you're applying a greater burden on them. You're putting them to a pedestal where you're saying, if you can't get here,
That's your problem, man.
and you can't call that rule and reason.
I hear you. The intent of the rule of reason seems to be that we can allow for a practice that is potentially anti-competitive to continue if, in the grand scheme of things, that can be a net positive effect. So the court is invited to consider those. So I'm asking, how does the rule of reason agree with the premise that you're trying to advance to us?
My lords, I'm exactly setting it in the premise that you have just cited. That when you hold that this is actually a dominant position that has been violated, then you can look at the rule of reason analysis and state that when the joint venture is not allowed to access 8G, it might as well develop 76G and 9G, 10G. That will foster competition.
But there I have to first consider that it is more beneficial for you to be that sole. Actually, that benefit that you're citing to us is a greater benefit than if, in a market that we're trying to defeat environmental pollution and greenhouse gas emissions, we allow competitors to access a faster smart charging option by accessing 8G. Don't you, when you weigh those benefits, which is the greater benefit?
My lord, and I hear you, my lord. I simply submit that when you look at innovation, we have come from 1G, we are now at 8G. We are looking for the fastest way we can get to 9G. And I submit that is benefit enough, my lord. That if we allow this exclusive agreement to continue, then we can foster competition. And that is simply our case. Your Lordships, I will now recognize that my time is fast spent. Pray that you hold this issue and declare it in the negative and invite core counsel to address this court on issue 2 and 3. Much obliged.
Thank you, my lords, for court record once again. My name is Marvin Insereko. I will be submitting or responding to issues 2 and 3 respectively. And on the ground of issue 2, whether the Eco-Motors and Solar Wheels collaborative partnership, which is also referred to as the JV, has transformed into an anti-competitive cartel. What a cartel is, I will pray that this honorable court be persuaded by the 2009 decision of the Supreme Court of the United States, in its case of the United States versus National Lead Corporation of 2009. This court defined a cartel to mean any agreement between two competitors to cooperate and win customers by means such as price fixing,
bid rigging, market sharing, among others. Now, my lords, in responding to issue 2, I'm simply going to establish that there was a cartel and that this cartel had transformed into an anti-competitive cartel. Now, with this, my lords, with this definition, it is clear from our facts that according to paragraph 7 of the facts, Eco Motors and Solar Wheels clearly transformed into a joint venture, and with that, my lords, they cooperated and they came together as two separate competitors to win the market under which they were going to operate. Now, my lords, that means that this has become a cartel. Now, on the question of whether or not this cartel has become anti-competitive, the respondent submits that first, I pray that this Honourable Court is persuaded by the Treaty on the Functioning of the European Communities under specifically Article 101. Now, Article 101 of this treaty specifically bans all agreements, decisions, or concerted practices that give an adverse effect on the market of competition. Now, this article in itself does not ban cartels. It is important for this court to note. However, it bans decisions, agreements, or concerted practices that have an adverse effect on the market. Competition. Now, on the competition. Thank you, my lord. Now, my lord, on that ground, I submit that the joint venture had transformed into an anti-competitive cartel, giving recourse to paragraph 13 of our facts. Now, the Uganda Regulatory Authority of Antitrust Laws, in its investigation, found out that the joint venture was sharing and exchanging information beyond the scope of their collaboration. Now, with that, we submit, your lordships, that this clearly falls in the definition of what a cartel is, and as such, is my lord.
I have a question, because when you say the work found that made that finding, it is the reason that we're here, and in their submissions they pointed out that the finding had to be wrong because this is one of the exempt kinds of agreements, exempt collaboration for purposes of research which became necessary only because your client, had foreclosed the market from them. At least that's what has been submitted. How do you address that?
That is a very interesting question. However, in the response, I will submit that, you see, we are not against the joint venture or their collaboration. What we are against is that they went beyond the scope of their collaboration. That's exactly my point.
So how did they go beyond the scope?
Much obliged, your lordship. Giving recourse to this paragraph, it is clear that they exchange information. Now, we are simply saying that, basing on the Treaty for the Functioning of the European Union, it bars all agreements or concerted practices that include price fixing, bid rigging,
at what point
limitation.
Do you see price fixing in this?
Much obliged, your lordship. Now, the effect of sharing or exchanging information, such vices are inevitable. My lord, I'm going to submit on specifically the vice of market sharing. Now, it is clear that these two are the competitors in the same market. Now, when they come up with a joint venture and they start exchanging information that is relevant and that is sensitive on their clients, on the market, and limiting supply and production, we submit that with such, it becomes an anti-competitive cartel because such are anti-competitive behaviors and practices that are bad or that are limited.
I think you're painting with broad strokes. I need you to be a little bit more specific. Because simply because we are, especially now, I want you to now get into the reality of this part. Paragraph 7 tells us that the purpose of their joint venture, let us examine, because remember we're trying to see if work was right in finding that their collaboration was anti-competitive. What was the purpose for which they collaborated? To develop electric vehicles, right, with advanced charging technologies, with the aim of starting a cost-effective ride-hailing service. If you're trying to come up with something cost-effective, and that is the submission that we had from the applicant, it is inevitable that you, especially when you're giving, when you're doing this as a venture, a joint venture, it is inevitable that one of the things you need to exchange is how you're going to price these components. So I do not see how pricing strategies is outside of the scope of the collaborative partnership whose purpose is a cost-effective ride-hailing service. So I want you to convince me otherwise.
Thank you, my Lord, for guiding me on that. However, in my response, I pray that this Honorable Court is persuaded by the decision of the Supreme Court of Zambia in Industrial Vehicles Limited versus the Competition and Consumer Protection Commission of Zambia, a decision of 2022. My Lords, in this case, Chief Justice Mambima held clearly that proof of a cartel is in itself sufficient without giving recourse to the adverse effects it brings to the competition or to the market.
So that test that you're citing for us is a test that I think, when we look at the broader jurisprudence of competition law, seems to be something that has been used in the past, but we've since moved on from it. Because if you're saying that we need only to look at a cartel, I want you to consider the decision of, if I'm not mistaken, the decision of the Court of Justice of the EU, which was considering particularly Article 101 and 102 of the TFU EU that you have cited for us. The decision in respect of, it was an advisory opinion, if I'm not mistaken, regarding whether Unilever had violated Article 102 and 101. So I'm interested in knowing if that court could find that exclusivity, just simply because there's an exclusivity agreement, does not mean that it's not sufficient to simply say there's an exclusivity agreement to hold that there has been anti-competition. Do you think by that same reasoning we cannot say that simply because there's a cartel, and you have also pointed us to that same reasoning, you do not necessarily conclude that it is anti-competitive? So how do you square those two decisions together? Because the Zambia decision you're citing for me is for which year?
22.
This is a 2023 decision, January.
Much obliged, my Lord. Now, my Lord, I was clear in my introduction and I said that existence, that Article 101 of
does not bar existence of
for the functioning of the European Union does not in itself bar existence of a cartel.
So how do you square the decision you're citing?
However, it is also important for us to note that any decisions or agreements or concerted practices that come from this cartel are what this article terms as illegal. Now,
so if you would have to rescind your answer that it is sufficient for you to establish a cartel for us to make the whole.
Much obliged, my Lord.
You have to prove some more, right?
Exactly. Now, in that position, thank you, my Lord, for that guidance. Now, on that position, the respondents submit that it was not only a cartel. This cartel also had decisions, agreements, and concerted practices that had an adverse effect to the market. And with that, we pray that this Honorable Court finds that this cartel transforms.
So it is those practices that we are interested in you addressing this court about.
What is the adverse effect that those practices had?
The thing that this court does not want to hear is that we have established it's a cartel. It's very easy to fit it within the subjective decision of definition of a cartel. We want you to show us what concerted practices, what things it did that you think had an adverse effect on competition.
So, like, my Lord, I appreciate your guidance, and I will submit that market sharing in itself that was done by Ecomotos and Solar Wheels in their joint venture.
What was the effect on that?
The effect of market sharing is that they limited, they intended to limit production, supply, and investment in the competition. On the other hand, is that they wanted to have an upper hand on the other actors in the competition.
That's exactly where we wanted you to go. So the question is, the reason that they are collaborating is because, if we see paragraph 9, it tells us they tried to get 8G frequency network, right? They couldn't. The reason they are collaborating towards that end is so that they can compete with your clients, Sky Connect, who have entered an exclusive agreement with Green Drive.
Yes.
That is them having an upper hand on everyone else in that. But these two are saying, let us collaborate so that we can at least have something that has 6G and 7G. And you're saying we should hold that to be an anti-competitive cartel?
And then I also feel like the respondents want to have their cake and eat it too, because your co-counsel says that they were pushing for competition.
You want them
to innovate, to get other. But then now, you want to limit.
In as much as I appreciate the innovation they came up with, this honorable court should desist from upholding an illegality.
What's the illegality?
Illegality herein is that they have absorbed the anti-competitive behaviors. My lords, if this honorable court is persuaded by clause 8 of the competition bill of 2022, it clearly establishes and defines and prohibits the anti-competitive behaviors. These behaviors,
particular behavior. That's why
the particular behavior is market sharing.
So let's talk about market sharing. What's your understanding of a joint venture?
My lord, according to clause 2 of the competition bill of 2022, a joint venture is defined to mean an enterprise, to mean where two enterprises in the same market join hands to control or have undertakings which are economically independent of each other.
Exactly. So notice that what they are doing here is that they have said, I'm bringing some resources, you're bringing some resources, we're creating a third entity that is going to do something separately from us, right? Naturally, some of those resources probably include, as they have said, because you keep saying market sharing, but we do not actually see it in this whatever, unless you're going to demonstrate it for me. What they do is they share, apparently, and this is merely a finding from the work, which we do not know the correctness of, but pricing strategies, sensitive business details. What are sensitive business details? This could include that in our car components, we have this thing that works for us. Include it. We have this thing that, and they hand it to the new entity that they have created. Surely don't you think that this is simply facilitating the new venture that they have created to participate in the market effectively, to compete effectively with Green Drive?
My lords,
has blocked their access to resources.
No, my lords, we submit and say that in as much as we appreciate the innovations of the joint venture,
Proceed.
The innovations of the joint venture, my lords, we do not applaud the applicants for coming up with illegal means to come up with such innovations, and as such,
and that's why I'm actually interested in knowing how you arrive at the fact that they are market sharing, as you call it, simply from the statement that work has found that they shared sensitive business details, pricing strategies, potentially, they didn't say that it does, potentially indicating anti-competitive behavior.
The decision of the European
If even work could not actually get that certitude about the anti-competitive behavior that they needed to qualify it and say potentially, where are you getting all this certainty that it had to be market sharing, it had to be this? Are you even aware of these sensitive details? How did you get to access the nature of the sensitive business details as to conclude that this had to be market sharing?
My lords, the decision of the European Court of the European Court of Justice in Courage versus Graham, the 2009 decision, clearly establishes that where there is one anti-competitive practice, it is going to lead to another and another and another. So where there is market sharing, it is vivid that these ventures shall come up with a
that's why this court is asking, where do you derive the idea that there is market sharing?
My lord,
simply because we have entered a joint venture,
no, my lord,
not necessarily
the fact that
the
fact that eco-motors and solar wheels are in the same market,
yes,
and they are exchanging information of their clients, sensitive information of how they operate, it means they are sharing information of that specific market. And we are
sharing
submitting,
market sharing, as far as I'm concerned, seem to be a little bit different. Unless you're asking this court to make the finding that you cannot have two players in the same market, say law firm with big law firm entering into a joint venture.
No, my lord. In fact, we are not against the joint venture.
No, I see that, but you're basically saying simply because they're in the same market and they have shared information, that has to be market sharing, which is anti-competitive. Perhaps maybe the easiest way you can go about this is paint for me a picture of how they could have done a joint venture that is not anti-competitive, in your opinion.
My lord, in my opinion, which is not conclusive.
Yes. Just your suggestion, how they could have done it differently.
I think,
in light especially of your client's behavior that has forced them
I
to
think
do a joint
as
venture.
my land colleague Azaria Ron submitted, we are simply fostering innovation. So we have not closed the door to
Yes,
other
how
innovations.
could they have innovated? Please go
My
on.
lord, we have other alternatives like 9G, 10G, 11G.
Still, they could have done it by sharing this
Pricing
whatever,
strategies,
sharing
and
pricing
information.
strategies, information, sensitive. I'm asking, how would it? Your time is up.
My lords, my time is fast spent. I pray that this honorable court grants me 2 minutes to
answer
conclude on
this question.
issue 3 and make the prayers of the
Anyway,
respondents.
I think we should let him go and he answers issue 3. I need to hear what you have to say about this
Thank you, my
collaborative
lords.
research.
My lords, I'm going to be brief because my time is fast spent. Issue 3 reads that whether the collaborative research and development efforts between eco-motors and solar wheels constitute legitimate technological innovations. My lords,
Which you said you want to encourage.
My lords, much obliged. My lords, we want to submit that these technological innovations were not legitimate. One, my lords, we submit by saying that a collaborative research and development is a partnership between 2 or more parties who work together to achieve a common goal. Now, the collaborative research and development we have between eco-motors and solar wheels becomes illegitimate where it goes beyond their collaborative partnership. And
Which you have still up to now not demonstrated. I do not know if I am taking a different opinion from your lordships, but I don't think you have demonstrated what aspect of the scope of this partnership that is set out in paragraph 7 they have exceeded.
My lords, I have submitted and said that I've submitted and asked this honorable court to be persuaded by the Treaty on the Functioning of the European Union, read together with Clause 8 of the Competition Bill, which clearly establishes anti-competitive behaviors.
And if you are to respond effectively, you also have to consider Section 6, 2A of the ESC Competition Act, which was cited by the applicant. Please address it directly and tell us how their research is illegitimate and does not fit within this exception.
Much obliged, your lordships. Now, the applicants, of course, relied on Section 6. However, they did not appreciate principles of reading statutes. My lord, they did not read it as a whole. The same section establishes for exceptions where such a rule or a section does not apply. Section 6 specifically, Clause 3, provides for the exception. Now, the exception is that where the collaborative research...
what?
3.
Not 4.
My lords, I beg for your indulgence and guidance, but it is Clause 3, my lord. Yes, where the collaborative research and partnership exchanges or has concerted practices that go beyond the scope of the collaborative research, then such a collaborative partnership cannot be protected under Section 6.
How have the applicant gone beyond that threshold?
Yeah, we are really keen to know. We have been keen to know from the start of your submission.
Thank you very much, your lordships. Now, we have established and we shall
Continue to establish.
continue to rely on our establishment that where the cartel or where the partnership shared information that was outside the scope of their collaboration, it was a collaboration to innovate, not a collaboration to share people's data, not a collaboration to come up with anti-competitive
Tell this court
practices.
how research and development typically works, especially when you're dealing with a technology that is data intensive, as ride hailing,
Thank you very much,
smart
my lords.
cars,
Now,
things like that. How does it work without information?
we also appreciate the fact that we are in a developing era, and a collaborative research and development clearly is that two companies are going to come and all bring different ideas and build
Ideas just story, actual
information, ideas, and build on each other's information, ideas, and practices. However, my lords, we are saying that where we have information of this kind, such information should as well be respected. These are two companies competing in the same market. When they come up with such information and they share it outside the scope of the collaborative partnership,
the understanding, and that's what for me I want to listen to. I hear you in that conclusion you make, but what's the threshold? What did the applicant?
At what point do we say, yeah, the applicant has now reached, or now the information they have shared is within scope? Because we have tried to establish their scope from paragraph 7.
Yeah, forgetting the environment that you try to picture, that this is competition. We are in an innovative kind of an arena. We have to share information. What threshold? And there are decisions to that end. If you could furnish me one.
My lords, I'm going to rely on the decision of the United States versus National Lead Corporation. The threshold set therein is that we look at the effects of this collaborative research and whether it outweighs the adverse outcomes from such a research. We are simply saying that the purpose of competition law is to limit or regulate
even if we take your, even if you
regime.
do take your reasoning there, I am interested in knowing how a cost-effective ride-hailing service is a more adverse effect than whatever strawman you're painting, you're telling us to go and strike.
My lord, a cost-effective ride-hailing service business is simply that these companies are coming up with an innovation like Uber, Safecar, or Lyft that are going to connect clients to cars. My lords, that is different from the scope that we are arguing on. We are arguing on the scope of developing smart charging system for electric vehicles.
Yes,
now, where this
and actually part of the scope is still including access to 6G and 7G frequencies with the aim. So these things are tied together. You can't sort of rip them apart. They are tied together, at least according to paragraph 7. So my question is, what's that adverse effect that you're saying? Weigh them for me. Show me that there is this adverse effect that is much greater than whatever benefit they're trying to give us, which is some cost-effective ride-hailing. Show me that by them sharing this information, and the only thing I'm getting out is a cost-effective service, cost-effective ride-hailing service, that's not sufficient. There needs to be something more. Like I should have gotten a better benefit. Show me what worse effect happened. That's what I'm interested in seeing.
sharing this sensitive data.
Which one?
The sensitive data that I've just established, the data of their clients, the market,
what negative effect does it
the
have?
negative effect that comes with that is that these companies are not licensed. They are not regulated.
That's not an effect. I am asking for effect.
My lord, this means that if they are not regulated, they are going to go. They are going to act broadly. And acting broadly means that they are going to share data beyond the scope. They are going to share data that is sensitive. They are going to share data that is not supposed to be shared. My lord,
but they are not licensed. I'm confused. They are not licensed to do what?
They are not licensed to carry out.
They are duly incorporated in Uganda.
Yes,
right?
my lord.
They are regulated by the laws of Uganda, including the data protection laws of Uganda. Those data protection laws have safeguards within which they have to operate. So now I'm interested in knowing what it is that will put them beyond.
If I will respond on that, my lord, Section 9 of the Data Protection and Privacy Act in itself bars any person to share information, collect, process without the consent
of the deriving the idea that they did not get consent.
My lords, we cannot presume that they got consent.
We can't presume either way. We can't presume they got consent. We can't presume they didn't get it. Aren't you asking us?
Yes, my lord. Now, putting that on a cost-benefit analysis, my lord, which one is the greater evil?
The benefit that they are trying to give us is a certain benefit. Cost-effective ride-hailing cars. The danger you're trying to have us avert is a clear speculation they may not have gotten some data. How does that?
No, my lord. What I'm trying to say is that even if they were licensed to do so, they were not in position to violate existing laws that regulate competition. The laws are clear, they set out what is prohibited, what must not be done, and if they come up and do whatever has been prohibited to be there, that means that they are bringing a greater evil, and with that we cannot risk taking greater evil. My lords, with that I pray that this honourable court finds that Green Drive did not have a dominant position under issue 1, and that under issue 2, the collaborative partnership of eco-motors and solar wheels constituted or transformed into an anti-competitive cartel. And under issue 3, we pray that this honourable court is inclined to find that the collaborative research and development constituted into an illegitimate technological innovation.
Thank you very much.
Much obliged, Your Lordship.
The respondents based the entirety of their argumentation on ideas that are typically against the principles of competition law as applied in the jurisdiction that they set. They want this court to believe that the United States, that has one of the strongest systems against antitrust policies and anti-competition, will allow an action where one company forecloses another company from accessing a crucial technology. Your Lordships, it's our submission that the applicants, the respondents, mislead this court when they say that the actions of Green Drive and Sky Connect, by virtue of the exclusive agreement, are not anti-competitive. Your Lordships, the first averment they make today is about the market, the relevant market in this case. Your Lordships, they submit that the relevant market are electric cars and not necessarily the SCC-enabled chip. But Your Lordships, from definition, a relevant market.
And I hate to interrupt, but I think they say the chip and not the car, right?
The cars are the
they say
the chip is merely a component.
A component. Oh,
Yeah.
all right.
Your Lordship, they say that the car is the market and the SCC-enabled chip is the component.
Yeah.
Your Lordship, a product market encompasses all relevant products and services for a particular industry. In this case, Your Lordships, it's our submission that the SCC-enabled chip and the cars are the relevant market in this case. Your Lordship, in the case of the United States versus Microsoft Corporation, the court, instead of holding that the relevant market was only the Microsoft Internet Explorer browser that came prepackaged with the computers, the court established that both the Internet Explorer browser that was under contention and the Intel chip that came pre-installed in the computer were the relevant product market because they cannot operate independently of each other. Your Lordship, on the argument of information sharing, I would like to persuade this court with the Indian Supreme Court case of Union of India versus Hindustan Development Corporation and others. At paragraph 16, the court clearly stated that in the absence of a specific agreement by a way of a concerted action suggesting conspiracy between parties in a collaboration, a claim of being anti-competitive cannot be sustained. Therefore, the respondent had the duty, like you tasked them, to prove critically where it was established that they shared this particular information. Your Lordships, on the argument of market sharing, Your Lordships, joint venture, the respondents do not understand the context with which joint ventures work. One, that the parties or the parent companies in a joint venture are supposed to act independently of the joint venture. That is, they proceed with other elements of their business and only collaborate in what they agreed to do.
The duty then was on the respondent team to prove to us that there was a spillover effect, Your Lordships, that came from this particular joint venture collaboration. Your Lordships, they failed to show us any areas beyond the scope of the joint venture that these particular companies collaborated, but only focused on price sharing. But even when they shared information on prices, Your Lordships, it's our submission that according to our strategic plan, it is in the consumer interest. And competition law is rather consumer-centric than industry-centric, meaning the interests of the consumer have to come first than the interests of the competitor.
Is that a response to their keenly placed argument that they are fostering you in a place of being innovative?
They are forcing you to innovate.
Is that a response?
Your Lordships, it's actually stifling innovation. Because at a point in time...
I appreciate you already stated that in that statement. I just wanted to know. Just proceed.
Okay. Much obliged, Your Excellency. Your Excellencies, while they accuse us of reading the law in bits, they actually do that. Your Lordships, they say that the treaty, the Treaty on the Functioning of the European Treaty, under Article 101, says that cartels are legal. I request for just 30 seconds to
finish that statement.
Yeah, they say that cartels are per se fine unless they have an effect on competition. Your Excellencies, my lords, at paragraph 102, at Article 102, the Treaty on the Functioning of the European Union specifies that cartels are per se illegal. Noticing verbatim that is important to this court, the first respondent states his argument basically on the legality of this cartel. It's our submission that this court is concerned with the collaboration. So their duty was to prove that this collaboration transformed into an anti-competitive cartel. My lords. My lords, with that, I beg to rest.
All right. We thank you very much. We have come to the end. We just want to be very careful that we... All right. So thank you very much. Yeah.
I said something. I wrote we were of the opinion that the respondents would surrender.
It was time provided for
Did you reserve time for that?
We reserve time for that, so.
But also to guide usually.
Now we joined as a very special circumstance.
We unless you're making anything
groundbreaking rejoined.
Yeah,
but we have already considered most of the arguments that you've made. We will take them into account in response to how we can potentially respond to what has been presented.
Much obliged.
All right, so that brings us to the end of the round one. No comments. I think we'll briefly in just.
My lord, I hate to belittle the court, but the rules seem to indicate, and what we relied on, that each team would have 5 minutes for it.
All right, so I'll guide as you take your seat. I'll guide as you take your seat. All right. So, for prudence, I will let you rejoin. Yeah. But even in normal practice, it's before the High Court. In no way do you have a right. Yes. So that's why I was declined to, allow you to rejoin. But as you gladly now you want to refer to the rules, and we had requested the organizers again to make mention of that to you. I will permit that, but in less than, I think, 2 minutes. Firstly, that you didn't actually make mention of that. Yeah, you remember that? So I'm very hesitant. You've insisted, so I'll accord you that. And that's why I'm saying you only do that for things that you think will...
You better be rejoining, actually.
And I hate to interrupt you because I'll only allow you to make responses to the rebuttal. Yeah. So I was just giving guidance that you're hardly given such an occasion. Yeah, so you use your time, and they only are allowed to do the rebuttal.
Yeah, there are Supreme Court decisions to that effect.
Yeah, but 2 minutes, 2 minutes strictly to the rebuttal, specifically to the rebuttal. Yeah, you only make responses to the rebuttal.
My lords, much obliged for the chance to. Sorry, but I will start with the argument that has been advanced on market sharing. Your Lordships, it is the opinion of the applicants that in market sharing we should demonstrate a spillover effect from their market sharing that would have an adverse effect. I would refer this Honourable Court to paragraph 10 then to show you that there was an intermittent access of 8G frequency which they were not licensed to do, and that extent it justifies a spillover effect, and it is an effect because it is a competition in the relevant market. Subsequently, Your Lordship, I will now address the argument of what concerted practices do we seek to address from the collaboration. Your Lordships, when you read the Competition Bill of 2022, Clause 8.3, it suggests that sharing of pricing strategies and selling strategies is illegal. And to that extent, I invite you to look at paragraph 13, specifically the last line. The start says that they shared pricing strategies, and to that end, it was an illegality, as my learned friend has highlighted. Your Lordships, I will now conclude with the argument of stifling innovation. Your Lordships, they submitted that we stifle innovation by limiting competition. That argument would make sense if there was no innovation of 8G frequencies, but there is already an innovation. What are we stifling by stopping you from using an innovated measure for you to use other entities that have not been innovated? Your Lordships, as we conclude, we submit that while you are adjudicating over this matter, you adjudicate all issues in the favor of the respondents. Much obliged.
All right, so that brings us to the end. I will let the members of the bench give comments briefly, very briefly, and we'll see you out.
Yeah. Thank you, Judge. My comment, I think I'll just make one comment, and it's really just a takeaway for rounds going forward. And across the board, many of us were struggling to see where the judges were trying to take us with their questions. If you can learn to read through those lines a little more quickly, it will save you time, it will save the court time, it will help everyone to make their arguments very well. Otherwise, I think we had a really good round. Everyone put up a good fight, and may the best team.
This was a very good round, as Joel has said. So just to take away for the next rounds that you're going to have, in a moot session, the most important thing is to answer the judge's questions. So much as you're able to address your issue 1 and 2 that you prepared for, if you don't answer the judge's questions, you won't get the marks. And also, a team is as strong as its weakest link, so all of you have to put in the effort, because if one of your teammates is doing really well and then you're not doing that well, it will affect your average. So all the best in the next round.
I'll make a few comments, things I've seen from the team members. I think some of you try to frown when being asked too many questions. Avoid frowning at judges. I think you've been doing that. You've been getting annoyed at questions being asked. So don't frown. Be calm when asked questions. Respond politely and address them. Don't frown. Then 2, interjecting judges when they're asking questions. Probably have done it. Should not do that. Let the question come out, then respond to it respectively. Don't interject. Then the other is citing wrong sources, or someone citing the competition bill that has no definition of dominant position. Such on that is defining the dominancy by citing the bill. It is missing the bill. I don't know where it came from. So you need to have right sources for definitions. And then lastly, avoid being sober boss. Go straight to the point. Don't beat around the bush and look for the point out of the blue. Go straight and hit it, and you'll be good to go. Hopefully one of you wins. The best of luck.
All right. So thank you very much. Oralists.
And the researchers.
And the researchers. Yes.
Good job, researchers.
Yeah. We would have had a terrible round if the research was bad.
Certainly. You can tell that there was, an input from the researchers. So well done. My comment is very simple. When you tell court that I will say this, please say it. Yeah? However, I don't know, we take you through, if you're going to Wandegea, and then we first make you pass Kololo. The moment you say, Your Lordships, I will submit under 3 head averments. Firstly, that there is this. Secondly, that there is this. Whether we take you around, I don't know. It's very important that you say, I have now concluded this. Maybe your question points me to the second averment, right? And conclusively, I have answered the third averment. The reason that is because that's a roadmap. So when you say something, we're right. We wait on you. It's very, very bad when we keep waiting, and even in the wake of questions, you're not responding. You're not, because that, for me, it informs me that you're not fed into your submission, that you're not alive to say, oh, the judge just pointed me to that question, leads me to the second element that I was going to address them on. Do you get that? Very, very pertinent. And finally, you are lawyers, you are advocates. Time never gets done and then you sit down. You're here. Don't
put up a fight.
You know, even in normal court, you will see. Yeah, you really.
At least give yourself a minute.
You will actually say, Your Lordship, my colleague interrupted me. I was in a normal court. You will see the things. My colleague Joel he kept interjecting, objection. I'm requesting for a minute to make my case now. You know, the element of that shows me that you're actually very in sync with your matter. Yeah, and you really want to advocate, but also conclusively that you just don't sit down, right? So what do we take? You told us, guys, I'm going to fight. Then when you say the time is up, you just sit down. Yeah, that's really a training thing. Please don't take it from Then finally, every moot court has principles. For me, really today, what I was looking at is, apply those principles. Yeah, it shows me that there has been an element of reading. The researchers have done their role. So the question is asked, you say no. That's a rule on appreciability, right? And that has been, exactly. Yes, you come up with a very catchy introduction how we don't have competition law here, in the East African region. Then you now, after that, you don't infer to things like we can infer, we can appreciate. It's a growth. We have an act. I think in the East African countries, it's only, I think, Kenya and TZ, Uganda were strong. Even Burundi, you can imagine, Burundi has a competition law. Uganda, Tetulina. So you see, that's where you have, that's what I was looking out for, and that for me shows me that as an oralist, when you apply the principles, even when you don't just make mention of them, but you say, let's be guided by this, rather than just saying competition law requires us to see this, but when you infer the principle and say, let that principle guide your question, Your Lordship, that shows that you have had input, So thank you very much, and we'll see you on the other side, Yes. No, I think they can leave. It's okay, they can leave.
You guys are free to leave. I'm not holding you back.
Wonderful news. That's what we are waiting for.
Does that mean food?
Breakfast.
Loosely translated as.
Loosely translated. Stop implying. It means breakfast.
Don't imply.
So you guys are done with your ballots?
I think I'm done.
I am done with the ladies of Brazil.
There's about 5 minutes I've had before the next round, so I advise you to go now.
And have that. Mr. Chair, the reviews are there.
Where your results?
You have to comments.
As always, it has to be exceptional.